the boss.
All right. All right, I'm going to bang the gavel. Hi, how's everybody out there today? Good. You guys are good? All right. Well, we're going to call the meeting order. We do not have a quorum yet, but James, can you call the roll to see who we do have here?
Absolutely, Mayor. I'm going to start off with yourself, Mayor Minto.
I'm kind of here.
City Manager Marlene Best.
Here.
Sheriff's Department Lieutenant Jarjura.
Here.
Dr. Mark Foreman.
Here.
Steve Stellman.
Here.
And then we have our honorary member, Danette McGlagan.
Here.
We do have 5 voting members present, Mayor, so if we get another 3, we can take action.
All right. Well, since we want to get started, but, we don't definitely have to have anything approved just yet. If they come in later, we can take that action. So we'll go from number 1 to number 3. And so do we have a update on neighborhood watch and crime prevention?
Yeah. We're stepping up our retail theft enforcement. So we just did a detail last Thursday at Santee Trolley Square. That was very successful. We worked in conjunction with MTS. So they had guys at the trolley platform, and then we had uniformed officers and plainclothes in the stores. I was actually inside the TJ Maxx in the loss prevention office and inside Target, so it was pretty cool to see all the video cameras and how everybody works together. So we're definitely stepping up those enforcements. We're going to be doing those more frequently. As you guys are aware, the daylighting law, AB 413, we're going to begin citations as of March 1st. Since January 1st, the courtesy notices had gone out. We were placing those on vehicles. We pushed it on social media. It was also on the ready board at Cuyamaca and Magnolia for all drivers passing through that intersection, so they had notice. And we are talking with my traffic sergeant. We're going to try to initiate e-bike and e-motorcycle education at the high schools. Apparently, before COVID, Grossmont was doing the education, but for whatever reason, it stopped. So we're really going to try to push to get that back.
Great. Sounds good. Certainly.
I really support the education that you're doing on the motorcycles and motorcycle safety. I started riding motorcycles a long time ago in the 1970s, and what I remember to this day, whenever I have ridden for all those decades, was the initial education that I got when I was around 15, 16 years old. So it's kind of an important thing. It's a dangerous thing that people engage in, and it's extremely fun when you do it. So it can stick. It can grab on and hang on to somebody that they carry with them for the lifelong.
Didn't you used to ride motorcycles for the police department? Yeah. Did you just say that and I didn't hear it? Or okay. I was kind of deep in thought because I just came from a meeting where the district attorney, Summer Steffen, did a come on in, did a presentation, and it had referred to Prop 36, and a portion of it was on the thefts, retail thefts, and since it became in law, I think she said there's been 340 prosecutions now. Arrests and prosecutions in our county, and so that's I think about between 60 and 80. She said they're getting a week in reviewing, so that's huge. And some of the she told one funny story was about a fella who was following Prop 36 really close, and one of the things that he realized is that not only is if you commit a theft over the $950 now a felony, however, it's an aggregated prosecution also. So if you go out one day, and didn't used to even be like this prior to Prop 47, if you go out and you do, let's say, 6, thefts a day and they're $1,052, well, that's a felony because they can put them all together now and prosecute them that way. And so this one fella, he was under the impression that, like many laws, it takes effect on January 1st. And unfortunately, that's not how it works with a People's Initiative. People's Initiative, it is passed by the people. It goes to a certification hearing to certify the election, and 5 days later becomes law. So on that 6th day, he actually went out and did a theft and got arrested. He goes, "What are you doing? It didn't take effect yet." And they said, "Well, sorry to tell you, but yeah, it did." And so now he's doing some time for the crime. So that might be a really good presentation for us to hear also, because she also covered a lot of the new laws as they pertain to drugs and under the influence and things of that nature. And it was very interesting because some of the things that we never even used to have before, they do have based on Prop 36, including forcing people that, like, after, let's say you get 2 misdemeanors for possession of, let's say, some methamphetamine or cocaine, which are pretty much misdemeanors these days. Well, on the 3rd one, you can actually be forced into incarceration and treatment. It doesn't have to be, a big felony in order to get something like that. So all these little things that are going into effect and whatnot are actually going to be really good for us. And I know you guys are getting a ton of training over at the sheriff's office, or, well, at least the guys that work for you are. And but it might be real good, James. I'll give you a name to call over there later. So I think that would be a real good one, especially if we were able to do that, maybe in June even. That way it's a good 6 months of numbers that they might have for us. So just so very interesting that's happening now, especially at the stores. We might be able to reclaim our freedom of movement and picking things up off the shelf without having to call somebody with a key. Wouldn't that be nice to do again? So great. Thanks for that report. I appreciate that. And so that takes us to our item number 4, and Legal Aid Society of San Diego CARE Act presentation. Matter of fact, you guys probably have been involved in a lot of these discussions also over the Prop 36 and whatnot.
As for legal aid, they're not as involved in the criminal side of the bills that are being introduced, so I wouldn't say we're as knowledgeable on those.
Okay, gotcha.
Yeah. But thank you all for having us today. My name is Samantha Manganero. I'm a supervising attorney for our behavioral health unit at Legal Aid Society of San Diego, which is a smaller team within our larger health team, which is called the Consumer Center for Health Education and Advocacy. And I'll let Chris introduce themselves as well.
I'm Chris Hambleton. I am a staff attorney at Legal Aid Society of San Diego.
So today we'll be presenting on the CARE Act, which is also known as the Community Assistance, Recovery, and Empowerment Act. Before we get started, I just wanted to explain what our role is with the CARE Act at Legal Aid. So we're contracted by the County of San Diego to provide education and information on the CARE Act. We're not actually part of the CARE Act program. That is facilitated through the court systems and the public defender who represents the individuals who are participating in the program, but we're able to provide just an overview of what the CARE Act is. So with that said, I'll go to our next slide. Just an agenda to discuss what we'll be discussing today, an overview of legal aid, our behavioral health team, and then as it's pertaining to the CARE Act, we will explain who the key participants are, who's able to file a petition, and what the criteria is to be eligible for the CARE Act program, what information is needed to file a petition and what needs to be included in that petition. what the services and benefits of the CARE Act program are for the individuals that are participating. We'll be discussing that it is a voluntary program. Even though it's going through the court systems, there's no forced treatment, as there would be in a conservatorship, for example. We'll be discussing what the expectations of the county are when providing the services, and then discussing some common claims and misconceptions about the program, along with some resources as well. So Legal Aid, if you're not familiar, we are the largest nonprofit in San Diego, providing free legal services to low-income San Diegans. We have 3 different offices throughout the county, and Chris will get into some of our teams that we have at Legal Aid. But this slide also mentions our phone number to contact our direct line, along with the phone number to contact our health team, and then the extension for individuals to call if they have questions specifically about the CARE Act.
Right. So before we get into our presentation, we did want to explain some of the things that Legal Aid Society of San Diego does. It can kind of be summarized in that, 1, we only help with civil cases, so we don't assist in any criminal affairs. For that, you would go to the public defender. The second thing is Legal Aid Society of San Diego doesn't do any what are called fee-generating cases. So if you think of something where someone's likely to get a big payout that they can give a portion of to their attorney, like, say, a personal injury case, Legal Aid Society of San Diego probably won't be doing that because private attorneys are going to be willing to do that. Instead, we have teams that help with things like public benefits, so that might be SSI, food stamps, things like that. We have a family law team that takes select family law cases. We have an immigration team that does a very specific subset of immigration issues. We have a housing team that can help with things like discrimination claims or evictions. We have a special education team and a tax team. And then finally, we also have our health team, which is what we're a part of. That's called the Consumer Center for Health Education and Advocacy. That broader grouping assists with things like people trying to get access to healthcare, people trying to maintain their Medi-Cal benefits, or people who have quality of care issues. And then within that team, there's the behavioral health unit. And we do grievances and appeals for people who receive mental health services within the County of San Diego, specifically outpatient mental health services. So if someone is denied outpatient mental health services, or they have an issue with their provider, they would then file a claim with us, and we would investigate and render a decision to be reviewed by the county. If someone had problems with inpatient health services, for example, at a psychiatric ward or another inpatient setting, then they would go to Jewish Family Services.
I apologize, I wasn't using the microphone previously, so I'll try to be tall enough to reach it. So just to give an overview of what the CARE Act program is, it was implemented in October, on October 1st of 2023, so San Diego's about a year and a half in. San Diego was part of Cohort 1, so we were some of the first counties to implement the program. Now all of the counties in California have implemented the CARE Act, and so it's been interesting to see how it looks different in various counties throughout the state. But overall, the CARE Act, also known as Senate Bill 1338, it created a new pathway to connect individuals with voluntary outpatient treatment, specifically for those that are diagnosed with schizophrenia or other psychotic disorders. And through this program, they receive medication management, housing resources. They're connected to what's called ACT level treatment, which stands for Assertive Community Treatment, which is the highest level of outpatient treatment available in San Diego. The program itself is 12 months, and then at the end of the 12-month program, they can either graduate or they will have it extended for an additional 12 months, depending on their progress and their stability. Even after they graduate, if there's a change in circumstances, they can always, a new petition can be filed and they can participate in the program again. So this slide goes over some of the key participants of the program. one of our later slides will discuss who exactly can be a petitioner, but the petitioner is the individual or organization that files a petition for the respondent, who is the person that is in need of the services. So the respondent is the individual that is diagnosed with schizophrenia or another psychotic disorder, and they're subject to the actual care process program. A respondent can appoint a volunteer supporter to help them understand what is going on, help them communicate, and assist them with making decisions, as long as there's no conflict of interest between the respondent and their supporter. The public defender is charged with representing the respondents. Here in San Diego, there's one public defender that represents most of them, although I think now there is a second public defender that is taking on some cases as well. The County Behavioral Health Agency will also have counsel representing them through the process, and then the judge will be there serving as a neutral arbiter. Here in San Diego, I believe the judge's name is Judge Rosenstein, and she's done a great job. We've been able to observe some of the proceedings and seen that she's really been able to make it a welcoming environment for the respondents, who I think, can be intimidated by a court process.
Okay, so that gets us into who can file a petition. Any person who meets one of these criteria and is 18 years of age or older is able to file a petition with the court. So that can be someone who lives with the person who needs the services. It can be a family member, although family member is kind of a term of art in the CARE Act. So it, in fact, actually has to be a spouse, domestic partner, a parent, a sibling, child, or a grandparent. So if someone were merely an aunt or a cousin, they wouldn't qualify. But a family member can also be someone who stands in the place of a parent to the respondent. So anyone filing should just check those, make sure that they're on that list. It can also be a behavioral health professional who's treated the person within the last 30 days. A first responder, the person who needs services can file a petition on their own behalf to ask the court for those services. And then it can also be the director or designee of a hospital where the person's hospitalized, a nonprofit provider facility for the person who needs the services, the county behavioral health agency, the Office of Public Guardian or Conservator, or Adult Protective Services. And then in terms of the people who would qualify to receive CARE Act services, it would be anyone 18 years or older with a diagnosis of schizophrenia spectrum or other disorder. They have to have severe and persistent symptoms that interfere with daily living. They can't be stabilized in voluntary outpatient treatment, so if that person's already in a program, CARE isn't going to be the right solution for them. They have to be unlikely to survive safely and independently in the community, and their condition is deteriorating. Or it needs to be the case that they're getting to the point where without these services and intervention, that's what's going to happen. And then finally, participation in the CARE Act has to be the least restrictive alternative. So if the person's perfectly willing to walk into a different type of outpatient behavioral treatment, again, this probably isn't the right program for them. And they need to be able to benefit from participating in a care plan or a care agreement.
So this slide goes over the eligible diagnoses for the CARE Act program. I will say I'm not a clinician, so I'm not the best to describe what exactly these entail, but I can explain that the first two boxes are the diagnoses that qualify, which are those that are on the schizophrenia spectrum and then other psychotic disorders. I did want to make note of the diagnoses that do not meet eligibility. At this time, bipolar disorder is not a qualifying diagnosis, although there is a pending bill that may allow bipolar to be a qualifying diagnosis, although that was newly introduced and we don't have an update on that at this time. Also, psychotic disorders that are the result of a medical condition, so that could be a traumatic brain injury, for example, that causes someone to have psychotic-like symptoms, they would not qualify for the program. And then additionally, with the diagnosis, they do also have to have symptoms that are severe and persistent and interfering with their daily functioning. So as for what's needed when filing a petition, The petition itself is a form that's filled out. It's called a Care 100 form, and all of the associated forms can be located on the San Diego Superior Court's website. But as for the petition itself, the petitioner would want to include the respondent's name and address, or where they can be located if they're unhoused. They would go through all 6 of the eligibility criteria that Chris mentioned earlier. And then additionally, the petition does ask for supporting documentation, which is either in the form of a mental health declaration that would be filled out by a licensed behavioral health professional that has treated or attempted to treat the respondent in the past 60 days, or evidence that the respondent was detained for 2 periods of intensive treatment, which would be considered a 5250, which is a 14-day hold. So a 5150, which is a 72-hour hold, would not qualify. It would have to be the 14-day hold. However, here in San Diego, the court has accepted some petitions that don't have the supporting documentation, especially if it's a family member filing the petition and they may not have access to this documentation. So the court will make the ultimate decision if whatever information is in the petition is sufficient to move forward with the process, but preferably the petitions would have either of these supporting documentations attached to it.
And this intimidating looking slide is the care court process, but it's actually more simple than it appears. It's slightly different if the behavioral health provider for the county files first, but I'm just going to go through it as though it's a family member or other petitioner. So basically the first thing that happens is the petition gets filed, and then the judge kind of takes that petition back to their desk. They decide whether it looks like it's likely that the petition on its face, just with what's written there, does meet the CARE Act criteria. If the judge thinks that it does, then they will order the behavioral health provider for the county to open an investigation within 30 days to try to reach out to the person who the petition was filed for, try to engage them in services, and also try to see whether it's likely they meet the CARE Act criteria. Once the court gets that report, then they're going to they might dismiss the petition if it seems like the person is just going to engage in services without the entire care process. They might also dismiss the petition if it looks like that person obviously doesn't meet the CARE Act criteria. Or alternatively, they'll set an initial hearing that will be within 14 days. And then at the initial hearing, the person who filed the petition, the person that the petition was filed for, and the behavioral health provider all kind of meet. That's when the person the petition was filed for has an opportunity to substitute in their own counsel if they don't want, say, the public defender. And it's also when the court kind of lets the petitioner make an initial statement and then kind of substitutes the behavioral health provider in for the initial petitioner. After that, if the petitioner wants to stay involved, starting July 1st, they will have kind of a right to keep informed of ongoing proceedings. Or if the respondent, the person the petition was filed for, is okay with that person continuing to be involved, they can continue to be involved. But from there, basically, what happens is that the court is going to look at whether the person meets the criteria, and then if the person meets the criteria, then they and the county are going to work through a process to try to come to a care agreement about what that person's treatment is going to look like and what they want to get out of their treatment. There is a potential process where if the person didn't agree to treatment but seemed to meet all the criteria, the court could impose a care plan. In San Diego, the court hasn't opted to do that. The reason being that there's not really a mechanism in the CARE Act to force treatment on someone, so it's not going to be productive to force it on someone if they don't want it. And so instead, it'll get dismissed if the person doesn't want to engage in treatment. If they do want to engage in treatment, the care agreement will be installed, and then the behavioral health provider will start providing services to the respondent, and there will be follow-up hearings about every, I believe it's 60 days, to check that the county is complying with the care agreement and that it's still meeting the needs of the person that the care petition was filed for. This will go on for about a year, and then at the end of the year, the court evaluates, 1, does that person still seem to need services? Or 2, are they ready to graduate from the program? If the person still seems to need services, then the CARE Act or the CARE agreement can be extended for up to 1 year. And this is kind of a description of what a person can receive through that CARE agreement. So one is going to be community-based services. They're going to be what are called ACT-level services. And basically what that means is that rather than the person having to come in for different sets of appointments to receive counseling and things like that, the person will have service providers that are engaging in care coordination and meeting that person where they're at to help do things like remind them to take their medication, give them therapy or other psychological treatment, and help them to do things like apply for housing, apply for jobs, whatever it is that they need to do as part of their care plan. There are also select benefits when it comes to housing. Housing isn't guaranteed through a care agreement, but it is a possibility. And is that your slide?
Yes, thank you. So as Chris mentioned, housing is not guaranteed when participating in the program, but there is specific housing funds that each county has been provided for behavioral health bridge housing. So that's typically used when the county is doing their initial investigation. If the respondent that they are encountering is unhoused, they can offer temporary housing until they are more stabilized in a program where they can receive assistance to be connected to long-term housing. As for this slide also mentions that there will be an annual CARE Act report, which I don't believe has been released yet, but once it is, it will give us some more insight into what the housing placements have looked like within the program, and then that will help us kind of understand what typically happens. But I know here in San Diego that they do make use of those, the bridge housing funding for that temporary housing at the outset of the program. So one of the questions that a lot of people have is what happens if the respondent just doesn't want to participate at all. So the statute itself does not indicate that the respondent would be penalized if they fail to comply. So if they're choosing not to participate, they're not showing up for their court appearances, technically they're not going to be punished for that. It is a voluntary program, so if after numerous times they're not wanting to participate, it's likely that the petition will eventually be dismissed with the possibility for it to be refiled again at a later time. One other thing to keep in mind is if someone does enter into a care plan and they fail to participate and the petition itself is dismissed, if they are hospitalized within 6 months of that termination and they are being potentially looked at for a conservatorship, their failure to complete the care plan may be used as evidence in those proceedings, but it likely would not be the determining factor for them to be placed on a conservatorship.
And this slide is on what will happen if the county doesn't provide the things that it agreed to provide within that care agreement. A lot of this program is to build trust with respondents or people who normally wouldn't engage with the mental health system. So there are some hefty punishments if the county doesn't do basically what it promises it will do. So basically, if a judge were to find that the county substantially failed to comply with the care agreement, it can issue an order to show cause. It will ask the county to come and show, is it complying? And then if not, why? And then if they didn't comply, they can get a fine of up to $1,000 per day, not to exceed $25,000 for any single violation of the agreement. The funds then are supposed to be used by the county to assist people who would qualify for the CARE Act. And then if there's a series of noncompliances on the part of the county, then the judge can appoint basically a special master who will find services for that person that are what the person needs. And then those services will be provided at the county's expense, basically. And this slide is about common misconceptions about the program. One is that the care court mandates treatment. It doesn't. It's basically a pathway to voluntary treatment where kind of the authority of the judge and the fact that the county is going to be held accountable or used to incentivize people who normally wouldn't trust the process. The second is that the CARE Act program is for anyone with a kind of mental health condition. As we mentioned before, it's basically just the schizophrenia or psychotic disorder diagnoses for now. And then there's another misconception that the CARE Act program is designed only for people experiencing homelessness or primarily as a homelessness prevention program. And that's not true. A lot of the people who participate are homeless, others aren't. And housing support can be part of a care agreement, but it might also consist of a lot of other services that people need in this population.
So lastly, we just wanted to mention that our pro bono team at Legal Aid has various different self-help centers at the courthouses throughout San Diego. So there's 4 different self-help centers where potential petitioners can go in and receive assistance with filling out with the court forms, because many people are not familiar with how that procedure works. So the self-help center can assist with that process. They are not able to provide legal advice, but they can help provide guidance on filling out the petition and review it and help the petitioner determine if there's anything missing or anything that needs to be added or removed from the petition. And then again, we have our self-help phone line where anyone from the county or anywhere can call to get more information on the CARE Act program. And so here's just a slide with some information. I'm sure you're all familiar with the San Diego Access and Crisis Line, where people can call to receive referrals and community resources and access to various alcohol and drug support services. Our self-help phone line, again, is on this slide. There's a website that we've linked if you want to learn more about the CARE Act. There's a ton of different training videos that are typically meant for those that are working the actual program, like the county staff, but they're very informative just for anyone to watch if you want to look up more detailed information on the program. Cal HHS has working group meetings quarterly where you can hear more about how CARE is being implemented in other counties. There's also an option at the end for public comment so people can have their voice heard about any issues they may have or feedback they have about the program. And then lastly, all of the CARE Act forms and supporting documentation can be found on the Superior Court's website. All right, does anyone have any questions for us?
Actually, I'm going to go first here. This might not be a real popular thing to say, but I think that when we talked about, you had the one slide up and you had the 2 slides that are qualifiers, one's not qualifier. And there's a lot of discussion about homelessness and all that. And it would seem to me that homeless people would not qualify for any of this. And the reason why I say that is you say if they have to qualify under all the different sections. Well, if they're able to live on the streets, they're getting food, they're finding some kind of shelter, even if it's in an encampment. So they're actually functioning. So how could they possibly qualify? Because that sounds like one of the factors that, well, if they can't, keep themselves safe, they can't function, then they don't qualify for the CARE Act. So does that make sense, the way I'm saying that?
Go ahead.
Can't be a popular thing to say, but.
I understand what you're saying. I would say I don't believe the qualifications of the CARE Act are as stringent as you're saying, because it really just has to be that the person is decompensating. So even if, they've barely got someplace to stay and it's in one of these shelters, if that person is really at risk of, really at risk of being unstable, if that person is having a lot of difficulty maintaining it during their period of homelessness, then a lot of times, if they meet the clinical criteria, that's going to be enough. I think the criteria you're thinking of are more like grave disability, and that's more for things like if someone's going to be hospitalized, if someone's going to be put in a conservatorship, and that's when you start to look at things more like this person absolutely can't provide for any of their basic needs. The CARE Act criteria are simpler and less stringent than that.
Okay, well, see, that's what I was getting at, because it seems like if you have to be gravely disabled, most of those people, well, I won't say most, a lot of them are not gravely disabled because they are functioning. I see some people out there that, they outweigh me, so they're getting plenty to eat. So that's not an issue for them. And maybe that's not sensitive to say it that way, but it is the truth. And so I was curious about that. And then are you seeing people who are probably pre-homeless also that are going into this program? And the reason why I say pre-homeless is because they may become homeless because they're having some kind of issue, whether it's a breakdown or, let's say you've been, doing just fine, but now all of a sudden you're having a lot of these manic type depressive episodes. So you're not paying your rent, you're not paying your other bills. But if you get treatment, well, you know what? You'll get back on track with all that. So pre-homelessness is, I think, an important issue also for people who are starting down that road.
Yeah, I would say that yes, there are individuals that I would think would fit in that category of pre-homeless. Being unhoused is not a requirement to participate in the program. So if someone is having difficulties maintaining their housing or they're on the verge of potential homelessness, that might be a factor that would point them towards qualifying for this program if they're not stabilized in treatment and they need that additional support to be stabilized in the community.
Some of my experiences, I've seen people like, oh, we're not really concerned about those people because they're not there yet. And where's the compassion in that? Oh, let them get down on the bottom before you finally take care of them. That's not something I like to say is compassionate. So
yeah,
that's why I
agreed.
asked.
Yeah.
So, okay, anybody else?
Thank you for the reminder. I was curious about some of the data behind the first 18 months of the implementation. Do you know anything about the demographics of the petitioners in terms of there are certain different kinds of people who qualify to even be petitioners, and have the petitioners been spread across all of those qualifications, or has there been certain?
Yeah, that's a good question. I don't have the data in front of me, but I did remember seeing some sort of demographic breakdown of the petitioners. From what I remember, I think family members are a big chunk of the petitioners. I can't recall how else I think other than that, it's kind of like sporadic and goes into all of the different categories. But I would say, generally speaking, it's oftentimes family members that are initiating the petition or mental health providers.
And then similarly with the respondents, and kind of as a tag on to the mayor's question, do you know anything about overlap with other populations that other populations that may be targets for providing mental health services? The mayor brought up homelessness. You could think of other common populations like veterans populations or other things. Is there any overlap? Do you know, or are these kind of a separate population that weren't getting services and this provides an entry point?
Yeah, that's a good question. I don't know exactly what overlap there has been, but I will say I think a lot of respondents also have co-occurring substance use disorder diagnoses. And so while that can't be the primary diagnosis, they do often coincide. And so through this program, they also will receive treatment for that as well. So I don't know if that answers your question, but I would say that's maybe one overlap that I have seen.
Thank you.
Mm-hmm.
Kind of jumping off that a little bit, I think it's important to note that a lot of people that have substance use disorders are using those illicit substances as a form of medication. And so one of the best ways to quiet the voices in your head is to get drunk. But I work in substance use, so we oftentimes are making referrals now to the care court. We're on TV. Hopefully a lot of people are watching. I think it's important for people to understand that oftentimes what is a barrier to getting access to care is the mom or dad, sister or brother doesn't know where to go or what to do or who to call. Or they make a call and that person on the other end of the phone says, well, I need to talk to your brother. I can't talk to you. I have to assess him over the phone. The other thing is, and I'm glad that Judge Rosenstein is doing this, is that, you know, sometimes the difficulty is getting the initial diagnosis. Because people will say, well, I don't need treatment. I'm fine. Everybody can hear the same voices I hear. Everybody is responding to the same stimulus that I'm responding to. And so sometimes getting that initial diagnosis is very difficult. And so I'm happy to see that there's some opening up to say, let's go ahead and start the process here. And I bet when you get to the ACT program, we'll have a diagnosis for you within the first 30 days. So I think that's important to note. Are they jumping the line in the ACT programs? Because here's the truth about ACT, right? They're always full.
Yeah.
Very full. So if it's a court order, do they get priority? I know contracts in San Diego County have priority
Right.
for criminal justice involved clients. Can you speak about that?
Yeah, definitely. I would say in a way they are jumping the line because there is a specific ACT program through Telecare. So anyone that is participating in the CARE Act program will be automatically enrolled into this Telecare ACT program. If an individual was previously receiving services with a different ACT program, but they're not fully stabilized, but they've developed a rapport with that program, then they will likely stay with that program. But for those that are not engaged in any sort of treatment, they'll be automatically enrolled into the Telecare Act program, and thus they wouldn't have to be placed on a wait list like how you may have to if you're being referred through the ACT referral system through Optum in San Diego.
I think that's really important for people to know because, like I say, you've got mom and dad trying to get their son or daughter into care, and it's clear that their child either has schizophrenia or oftentimes where I come is from a substance-induced psychotic disorder. And they're making those phone calls, and it can be very disjointed. And so this is where you guys are just terrific at providing that wraparound care, having that oversight to say, you know, we're all together. And more than that, but going from that autonomy of care, individualized care, and kind of a paradigm shift away from that into a uniformed response where we all know Johnny now. Mm-hmm. Everybody knows who Johnny is. Their prescribers know who they are. Their treatment providers know who they are. Case managers know who they are. Law enforcement oftentimes will know who they are and say, you know, in contacting them, I'm in care court. And so there's that. It's a really important thing to understand is that you know, we've kind of all got, you know, think about the movie, What About Bob? Well, now everybody knows Bob, right? And so I think that's really important. But if anybody's watching, I think it's essential to understand that if you're having a problem getting your child or your loved one access to care, this is a really good first starting place for that. Thank you.
Thank you.
There's a lot here, isn't there? I noticed right before this screen there was a QR code.
Yes.
Could we either get a copy of this or I can scan it right here?
Yeah,
Cool.
I don't have it printed out, but it is a QR code that you can scan, and then I've sent the PowerPoint to James, so that could be sent out as well.
I grabbed it here, so thanks. Tracking this, it's a relatively new program, the way I'm understanding it. And do you have enough data yet to start showing that it's doing what it was intended to do? Like, is it trying to reduce some of these people showing up in the criminal justice system? Is it reducing hospitalizations? Is it reducing suicides or overdoses? Or, you know, the list could go on and on. Are you starting to see that it's having an impact or not?
Yeah, that's a good question. We haven't been able to see all of the data. That's typically something that's not directly shared with us. I think that will be in that annual CARE Act report that will eventually be available to the public to review. That will give some more insight on the data. I know at those working group meetings that I mentioned, oftentimes San Diego participates and they will give presentations and it gives a little bit more insight into the data. I don't have it, like I said, I don't have it here with me, but I would assume that it is helping prevent those using crisis and emergency room services from what I've seen and the few hearings that we've been able to attend. That is what we've gathered from that.
Okay. And as I'm recalling, it's quite a list of people who can be petitioners. You certainly got the family members. I think I saw first responders on there. I'm making an assumption that includes law enforcement and paramedics and firefighters.
Yes, that's correct.
Then mental health, behavioral health providers. There's some other ones on there also. So I thought I heard you say that the petitioner then can get updated on the processing or on the, I guess, how the case is progressing. How is that done without violating HIPAA?
Do you want to take that one?
Yeah, so basically they've limited the petitioner's kind of access after a certain point if the person so I'll start here. If the person that the petition was filed for, the respondent, wants the petitioner to be a part of the process and join them in that process and kind of be a support, then that person is basically allowed to come to all the hearings, assist the respondent, things like that. When it comes to if the petitioner, against the respondent's wishes, wants to keep apprised of proceedings, then the new law that will go into effect in July basically says no HIPAA information is allowed to go out in the updates. And basically the updates are that this type of hearing is happening on this date, they're going to do an update, and that's it. So it's basically a very formal, kind of high-level view of what's going on with the proceedings.
Okay, because kind of started the wheels working for me when I heard you brief on that, and then when I heard the mayor's question about the criteria, are they gravely disabled, et cetera, then I start thinking about competency. If somehow the individual is so far along on their disorder, are they competent to even say yes or no that I want somebody to be advised, which is really what HIPAA's partially is all about, is protecting those rights and having an advocate step up for them, say, hey, we need to kind of honor this and protect it. And mental wellness and mental health treatment is extremely complex and complicated when you get into that realm of, I want to keep this family member happy, so I'm just going to go ahead and wave this off, but I really don't want to talk to them. I don't want you to talk to them. And it's like you get in this kind of a double bind situation.
Yeah.
So it's kind of like what I started thinking about is you guys aren't the advocates for the patients, so I'm thinking that they may have advocates that would step up and help them navigate through that.
Yeah, so something I forgot to add about that process is naturally, so the respondent does have a public defender, or if they want, they can choose other counsel. And if the court wanted to, or if the court finds, thanks to the respondent bringing it up or their public defender bringing it up, that it would be detrimental to that person for the petitioner to continue to receive information, the court can also cut it off. So that person does have someone who's well-versed in the kind of legal standards for competency and in the respondent's needs to advocate for them to the court, and also, cut off if there's, say, a harmful petitioner who is involved in terms of the respondent.
Great. So I think one last thing is back to the, I guess, the first responders. Are they well enough informed, the first responders around the county, the firefighters, the paramedics, the law enforcers, that they can make a petition? Certainly through the PERT teams, I'm guessing. I would imagine that they are well aware of this, but there's thousands of first responders around that potentially have these repeated calls that they go to, that if they could have another resource to say, hey, here's a referral, here's a petition, might be a little bit of extra work for them. I know it would be extra work for them, but so where's the county at on that, of getting that word out to the people that are touching them right up front?
Yeah, I believe the county does discuss this with PERT, and then we also do a lot of outreach and presentations for the PERT teams as well. And we also receive lots of calls from first responders asking questions about the program. So I do believe that they're informed, but there's always room to continue to spread that word, which hopefully through this more will hear about it as well.
Okay, thanks.
Thank you.
Mr. Mayor, first I want to thank you very much for coming out today. Just to follow up on the last question, this, and I'm glad that Danette was able to bring it up, this is a recorded presentation, so no matter how many people are in the room, it is countywide, it is searchable on TV. people can come back and take a look at it. And from my seat, I believe that especially our fire department, but I believe the sheriff's department are aware of, the issues going on with the program. But we can also make sure that our chief and others are able to say, hey, go back, take a look at that. This could be a training. Do we need to have you guys come back out, et cetera? The city also has a homeless working group of a variety of advocates for those that are homeless, those that want to clean up encampments, anything related to homelessness. And we can provide this presentation as backup for that group. So any of those providers that are interested in finding out more, it may be that we want to ask you to come back and run through this presentation with that group again specifically. But I wanted to thank you because I know at least our city council here in Santee has been very interested in the care court process. When it was first proposed, it was something different than when it ended up after it went through the full legislative process. And it's been really difficult to figure out where is it at, what's going on. It can be somewhat complicated if you're not into the do's and the don'ts in the process. So I want to thank you for putting this together. It is something that I believe our city council is going to want to be aware of, as well as potentially others here in East County. We've heard a lot from various other cities here in East County that are trying to question and concern and trying to get updated. So the fact that you're here gives us an avenue to present that to multiple audiences all at the same time. So thank you so much.
Thank you.
Yeah, I thought of one more question, and I'm not sure if I heard correctly, but did you mention that this provides up to 1 year of services? Or there's a way to get an extension up to 1 year?
Yeah, the program itself is designed to be 12 months. If the individual graduates, they're not going to be left without any services. They'll be transitioned either into another ACT program. They'll make sure that they continue with that stabilization and service provision. If they are not if they're not ready to graduate at the end of 12 months and they still need that, court support where the court is checking in on them every 60 days and there needs to be more oversight of their treatment, then it can be extended for an additional 12 months. But regardless, when they're done with the program, they'll still be connected to that same level of ACT level services.
Thank you.
Mm-hmm. All right, thank you very much. Thank you so much for having us.
Appreciate it.
Mayor, before we go on to item 5, I did have a speaker slip on item 3, the neighborhood watch that I overlooked.
Okay, well, let's have that person come up then.
Carl?
Welcome, Carl. Sorry about that.
Yeah, not a problem. Couple of things. Actually, one thing that just popped up that added to my question, you're talking about you're getting ready to enforce the daylight parking. Is that going to be in residential neighborhoods as well?
Yes, the law doesn't just say non-residential areas or commercial.
Okay, I just noticed, I just know like the city of San Diego is prioritizing, downtown and those kind of areas first on North Park, but all right, thank you. The other question I had, which actually is you guys as well, I try and stay very aware of crime, neighborhood crime, using the calls for service, spot crime, and other things. And they're great on telling you, hey, this crime occurred. Doesn't tell you, is there a way of finding out if there was a resolution? Prime example, I noticed this morning, 3 out of the last 4 days, there's been a burglary or at least a burglary alarm right down on Shadow Hill. I live in the Shadow Hill neighborhood. There's also been at Creekside, there's been assaults. So my question is there a way of finding out, like, I'm out walking my dog, do I need to worry about that there's a guy out there assaulting people, or did you catch him? There's nothing that says arrest. Well, DUIs, but. And is there a way of getting further information, calling the station or doing something? Because to me, that's neighborhood watch kind of information.
You actually bring up something that a lot of people ask us about. And I wish we did have just a magic wand and we can get you guys everything that you want. Sometimes we can't release any information. And in general, even if it's sometimes the person that called, never mind just the neighbors that are interested, just even sometimes the person that called. There's always the generic ways of looking up who's been arrested, what their charges are. Sometimes social media, Sheriff's Department will put certain things out. But to be honest with you, there is no exact way that we have to communicate on all the different calls. Obviously, arrests are one thing; those can be looked up. But as far as somebody burglarized a home and then ran away,
Yeah, I
we
mean,
don't catch them.
Yeah, you're reporting the incident, but there's nothing that says, yeah, this store or this house was burglarized and we got the guy, and in fact, it could just be simply burglary, arrest made. That's the kind of thing I was just wondering about, because like I said, a lot of people walk. We don't have sidewalks. A lot of people are walking around. There's a park up there. You don't know if there's a guy out there assaulting or something, or if it was a one-off, or if it was I know a lot of them are